May shareholders in a close corporation enforce verbal agreements regarding the corporation's operations? The Maine Supreme Court considered that question as applied to a pizzeria and delivered their hot and tasty answer in writing in Villar versus Kernan. Frederick Villar and Peter Kernan opened Ricetta's Incorporated, a pizza business. Villar received 49% of the shares, and Kernan received 51%. Kernan claimed that the two of them agreed to take only distributions, not salaries. Later, restaurant manager Ronald Stephan acquired a 2% stake, 1% each from both Villar and Kernan. 6 years later, the business was thriving, but the relationship between Villar and Kernan wasn't. Kernan entered into a consulting agreement with Ricetta's, providing that Ricetta's would pay Kernan $2,000 a week. Kernan and Stephan ratified that agreement at a shareholders and board of directors meeting that Villar didn't attend. Pursuant to the agreement, Ricetta's paid Kernan $90,000 in 1994 and $24,000 in early 1995. Villar sued Kernan in federal court, alleging that Kernan had violated the oral agreement between them against either receiving a salary. The district court determined that despite the statute of frauds, the agreement could be enforced in equity. But it wasn't clear whether the Maine Corporation Statute prohibited enforcement of an oral contract between corporate shareholders barring receipt of salaries. So the district court certified a question of state law to the Maine Supreme Judicial Court, which agreed to consider the certified question.